Criminal law principles. Actus Reus, the act required to commit a given crime, a required component of every common law crime, along with mens rea. Requirement. To satisfy Actus Reus requirement, defendant must perform a voluntary physical act, such as a voluntary bodily movement. Omission as Actus Reus is a failure to act can constitute Actus Reus if 1. The defendant had a specific legal duty to act. 2. Defendant had knowledge of facts giving rise to the duty. And 3. It was reasonably possible for defendant to perform the duty. Mens rea is the mental element required at the time a crime was committed, a required element of common law crimes along with Actus Reus. Forms of mens rea is the intent requirement delivered by a crime. 1. Specific intent. Defendant must have specific intent or objective to commit a given crime. Specific intent must always be proven, never inferred. Mistake of fact and voluntary intoxication are defenses. 2. General intent. Defendant must be aware of his actions and any attendant circumstances, so it may be inferred from the act itself. Note that most crimes are general intent crimes. 3. Malice. Defendant acts with reckless disregard or undertakes an obvious risk from which a harmful result is expected. This applies to arson and common law murder. Strict liability. No intent or awareness is required for strict liability crimes. No mens rea requirement. Arises with statutory rape, regulatory, or morality crimes. Vicarious liability is a person without fault is held liable for another criminal's conduct, like respondent superior in torts. Often arises with employment or business associations. Model Penal Code mens rea standards. MBE questions occasionally invoke language from the MPC's fault standards. Thus, it is important to know these definitions. Purposefully is a subjective standard is when a person acts purposefully when his conscious objective is to engage in a certain conduct or cause a certain result. Knowingly is a subjective standard when a person acts knowingly when he is aware that his conduct is of a particular nature or knows that his conduct will necessarily or very likely cause a particular result. Recklessly. Subjective standard, a person acts recklessly when he knows of a substantial and unjustifiable risk and consciously disregards it. Negligence, which is an objective standard, a person acts negligently when he fails to become aware of the substantial and unjustifiable risk. Note, MBE generally tests common law unless otherwise instructed. Though the MBE usually tells you which law is applicable, when in doubt, apply common law. Major crimes and requisite mens rea. So for general intent, we have 1, battery, 2, rape, 3, kidnapping, and 4, false imprisonment. For specific intent, we have 1, attempt, 2, larceny and robbery, 3, forgery, 4, false pretenses, 5, embezzlement, 6, conspiracy, 7, assault, 8, burglary, 9, first-degree murder, and 10, solicitation. Malice is 1, common law murder, or 2, arson. Strict liability is 1, statutory rape, 2 regulatory crimes, 3 administrative crimes, and 4 morality crimes, such as bigamy and polygamy. Concurrence requirement. Defendant's criminal act and the requisite intent for the crime must occur simultaneously. For example, defendant plans on murdering victim at her home. Defendant is not guilty of murder if he accidentally runs over a victim with his car before reaching her house. Causation requirement. Defendant's conduct must be both the cause in fact and the proximate cause of the crime committed. Cause in fact, but for defendant's conduct, the result would not have occurred. Homicide and manslaughter. Any act by defendant that hastens victim's death is a cause in fact, even if death is already inevitable. Proximate cause. The actual result is the natural and probable consequence of defendant's conduct, even if it did not occur exactly as expected. Superseding factors break the chain of causation. Intervening acts must be entirely unforeseeable to shield defendant for liability. Examples are victim's refusal of medical treatment, third-party medical negligence. Both are foreseeable and defendant is liable. Note, causation issues often arise in homicide crimes on the MBE. Transferred intent doctrine. Defendant may be held liable if he intends the harm caused but causes it to a different victim or object than intended. Often applies to homicide, battery, and arson. Does not apply to attempt. Defenses and mitigating circumstances may also be transferred. Effect. Under transferred intent, defendant is usually charged with 2 crimes. 1, attempt to commit originally intended crime, and 2, the actual resulting crime. Defendant intends to shoot A but kills B. Defendant can be charged with attempt of murder of A and actual murder of B. Note, merger does not apply because there are different victims. Under the merger doctrine, 2 or more offenses merge, prohibiting defendant from being prosecuted separately for each crime. Merger concerns the relationship between either A, an incoherent offense, its completed substantive offense, or B, an offense and its lesser included offense. These only apply to solicitation and attempt. Merger prevents defendant from being convicted of both solicitation attempt and targeted offense. Defendant completes a burglary after attempting it. Defendant cannot be convicted of both attempt and burglary. Does not apply to conspiracy. Defendant can be convicted of conspiracy to commit a given crime and the crime itself. Lesser included offenses. Defendant cannot be convicted of a target crime and a lesser included offense. Lesser included offenses consist of the same but not all the elements as the greater crime. For example, defendant robs a victim, but during the robbery, defendant accomplice kills the victim. Defendant can be convicted of felony murder, but the lesser included robbery offense, but not the lesser included robbery offense. Note, also barred by double jeopardy. Note, crimes with different victims never merge. Accomplice liability. Requirements. To be liable as an accomplice, one must A, aid, counsel, or encourage principal before or during the crime. 2, with the intent, A, to assist the principal, and B, that the principal commit the crime. Scope of liability. Accomplice is liable for the crime he committed or counseled and any other probable or foreseeable crime committed. Defenses and exceptions. Accomplice liability does not apply where withdrawal. An accomplice can avoid liability by withdrawing from a crime before the principal commits it. Accomplice must 1, repudiate prior aid or encouragement. 2, do all that is possible to counteract the prior aid. And 3, do so before the chain of events is in motion and unstoppable. Members of a protected class. Those protected by a criminal statute are not liable as accomplices, such as minor victims in statutory rape cases are not liable as accomplices to statutory rape. Parties not provided for in the statute. A purchaser of drugs cannot be an accomplice to the seller. Accessories after the fact. Different than accomplice liability, it involves helping a known felon escape arrest, trial, or conviction. Gives rise to separate lesser charge of obstruction of justice.